tonight. Tonight, as you all know, we're going to be discussing Stand Your Ground. It's the controversial self-defense law that has gained a lot of attention, mostly out of the state of Florida. But I want you all to know that Stand Your Ground is a law that can be it can be applied anywhere in any U.S. jurisdiction. And so my goal tonight is to make sure that we educate you all on Stand Your Ground, that you're appropriately educated on it, and that you don't get it from hearsay, or that you don't get it from rumors that you hear other people talking about. We want to make sure that you understand what it is from professionals. And so before we get into the panel discussion, as you all know, it is election season here in Calhoun County, and I see that we have a few elected officials as well as people who are actually running for public office. So if you are in any of those two categories, I would ask that you please stand and introduce yourself to the audience.
My name is McGlaughn. I'm running for sheriff of Calhoun County.
I'm David Reddick. I'm a standing city council, but I'm also running for re-election of the Alabama Democratic Executive Committee. I'm running for re-election for that.
I'm Ted Copeland. I'm running for the State House of Representatives, District 40, which includes Jacksonville here in Jacksonville State.
Anyone else? Any other elected officials or anyone who's a candidate for a position? Okay. All right. We thank you all. We welcome you all here as well. Before we get started, we're going to, as you all probably noticed up on our projection screen up here, we're going to be having some inspirational poetry. I wanted to start it off inspirationally because Stand Your Ground and violence and death and things like that, it could be a really tough topic to talk about. And so I want to make sure that we start off the right way and that we start off with a little bit of inspiration and something for the soul. So I would like to bring down to the front now a motivational speaker and spoken word artist here in the Northeast Alabama area, Mr. LaQuinton Lyrical Forte Ragland.
Well, it truly means a lot to me to be able to present to you here today. And the piece that I'll be performing today is simply entitled, Stand Your Ground. I think it's time that we stand our ground. See, there's this thing on the tip of my brain called a thought. Yes, it seems like our dreams have been filled up with false hope, sold by sellers who have mocked our endeavors. Therefore, it seems like our dreams we have fought. See, I think it's time that we stand our ground. I'm sorry, I'm a little nervous, y'all. Please bear with me. We start over. I think it's time that we stand our ground. See, there's this thing on the tip of my brain called a thought. See, it seems like our dreams have been filled up with false hope, sold by sellers who have mocked our endeavors. Therefore, it seems like our dreams have been fought. See, I think it's time that we stand our ground. You see, Black History should be a month, the shortest month, but every day should be a holiday because for us it hasn't always been oh so sweet and oh so amazing. Then again, we begin to sell ourselves short. When some major injustice happens, we start packing, doing major demonstrations, protests, and big-time news reports. Then the following week, when nothing has changed, everything has went to going back to being the same, and our whole mission goes aboard. So I think it's time that we stand our ground. See, we live in a world where people shoot first and ask questions never, killing our future endeavors to embezzle the dreams of teens. Social injustice says it's not as bad as it may seem when a young teen at the age of 17 dies by an unjustified homicide while only carrying a bag of Skittles and a can of Arizona iced tea. I think it's time that we stand our ground. See, Dr. Martin Luther King's dream has been resurfaced and found, and the march to Selma, Alabama has been relocated to another town called Sanford, Florida. 269 miles from the unjust death of Troy Davis in Savannah, Georgia. 1,176 miles from the wrongful death of 22-year-old Rekia Boyd, shot by an off-duty Chicago cop. leaving her mother without a daughter. 1,204 miles from the Oklahoma shooting rampage of 2 men shooting 5 men on the north side of Tulsa. Just because you don't see it in your big-time media news doesn't mean it's not happening to other sisters and brothers. We got to stop killing our own sisters and brothers and be the keepers of our sisters and brothers. Just sisters and brothers from another mother that need to be there for each other. So I think it's time that we stand our ground. A group of teens play loud sounds, so that justifies 10 rounds. 17-year-old Jordan Davis shot down. Michael Dunn guilty on 4 counts. Yet first-degree murder is declared a mistrial. I think it's time that we stop sitting down and talk about this law. There's nothing justifiable about our young, innocent teens' lives being lost. Let us not wait till our own loved ones are being lost. I think it's time that we stand our own ground. Thank you.
Thank you, Lyrical Forte. Okay, now this is the part where I try to introduce the group to you all just a little bit. This is a group that is very new, and when I say new, I mean it's pretty new. We've only been in existence since January the 1st. That's when we launched. The Justice and Civil Rights Initiative, our mission is to provide advocacy for people who are victims of civil and human wrongdoing. We also make sure that we aid in the progression of civil and social issues around the world. One of the reasons why, as the founder, I wanted to start this group was because I used to be a reporter here in the city of Jacksonville at the radio station on WLJS 91.9 FM. I worked there for 3 years. And I was called in November of last year, right around the holidays, to start this civil and human rights group because, as a reporter, I saw so many injustices that I kind of pulled at my heartstrings a little bit. And I said to myself, well, somebody's got to do something about these things happening in the world. And we have our Dr. Kings, and we have our Malcolm X's, and we have our Sojourner Truths, and we have all these other people who have come throughout the world and tried to make a change, and I decided I wanted to be a part of that change as well. So I started taking some notes. I started making some phone calls to some officials across the area, and I got some backing up. And then I decided to appoint my vice president, Torsten Dryden. He serves as the Chief Justice here at Jacksonville State University. If once the photo rotates, you'll see his picture up there with me and the rest of my executive cabinet. And there are 7 of us on the executive cabinet, myself, the vice president, and we have Vice President of Public Affairs, Angelique Killebrew. We have our secretary, who is Emily E. Roberts. We have our Vice President of Risk Management, Colby Donner, and we have our treasurer, Mark Hunter. And we have our Vice President of Administration, Tyler Seuss. And those are the people that make up the Justice and Civil Rights Initiative. And our goal is to make sure that when we talk about civil and human rights, I want to make sure I make everyone very clear about something. Civil and human rights can affect anybody at any time for any reason at all. A lot of people, when they think about civil rights, they think of the African American civil rights movement, as in the 1950s and the 1960s and Jim Crow and segregation in the South. Those things are civil and human rights. They are. But I want people to know that any reason with anybody of any color can encounter a civil rights issue. We've investigated 9 cases, me and my executive cabinet. We've investigated 9 cases of civil and human rights issues from calls of people that have called us and that have wanted our assistance. 7 of those cases have been officially resolved, and 2 of those cases are pending. And they're pending only because we just received those calls within the past 5 to 7 days. And so we're still trying to work with those victims as well. And they've been a myriad of things. I had someone call one time saying that they were discriminated because they were transgender. Okay, it's not something we really think about every now and again, do we? I also had someone calling me to tell me that their house was, they unknowingly gave their house away to the state. So we worked with her and we helped her make sure that she was well within her rights to get her property back. And so it's all different kinds of things that we've dealt with we've tried to assist people in making sure that their rights were not trampled on or infringed. And so I want to make sure that tonight, as I speak with the panel and as you all listen, I want you all to do your very best, your absolute very best, to listen with an open mind and an open heart, and I hope you're well received. Excuse me, I hope the information that you receive is well received within your heart, your mind, your body, and your soul. And so without further ado, I'm going to go ahead and introduce our panel here. I ask that during the discussion with the panel that you please be very respectful of the panel. Try not to move around a whole lot. I understand, some people have to maybe get up and go to the restroom and take a phone call. That's quite all right. These dignitaries have taken time out of their precious schedules to be a part of this event this evening, so we ask that you please show them the utmost respect. They are going to be more than likely giving facts, and at some point in time they will probably be giving their opinions about something. We ask that you please be respectful of their opinions and not blurt out anything, and please do not do any type of carrying on whatsoever. So I'm going to go ahead and introduce the panel. Right here we have Ross McGlaughn. Ross McGlaughn is a police officer with the Heflin Police Department in Cleveland County. He is also a candidate for the Calhoun County Sheriff's Office. Next to Mr. McGlaughn, we have Shawn Giddy. Shawn Giddy serves as the university's chief of police. And to his left, we have David E. Reddick. Mr. Reddick serves on the Anniston City Council for Ward 2. And next to Mr. Reddick, we have Marcus Reid, who is the Chief Assistant District Attorney of Etowah County. Please give our panel a round of applause. Okay. You ready, panel? The first question that I'm going to start off with is, I think, is the question that everyone came here to have answered. And I'm going to go ahead and start off with Assistant District Attorney Reid for this question. You have gone to school, you are an attorney, you've gone to school, you've taken the bar, and so I think you're probably well equipped to answer this question for us. Exactly what is Stand Your Ground, and does Alabama have a version of it?
How long do we have?
Well, let's see.
Well, I'll say this, I finished law school 32 years ago. And I was a practicing attorney for 23 years. I've been prosecuting for really 20. There was overlap there. So I think I know a little bit about the law, but the law is an ever-evolving thing. It changes. It's a changing body. And to understand the Stand Your Ground law, you really have to understand how we got to Stand Your Ground historically. Because there was and it really goes back to the common law. This Castle Doctrine that people talk about the Castle Doctrine. That is something that was embedded in the law at common law. And gradually, the duty to retreat became part of that. So it's a humane sort of principle that, you have the right to defend your castle, your home, from intruders. And you have a right to defend your family. That's the Castle Doctrine. You also have an inherent right to self-defense. You have a right to defend yourself. If you're being threatened by somebody, and Alabama law codifies that. For years, I tried cases under the pre-existing self-defense law, which basically said if someone is attempting to physically assault you, you have a right to use reasonable force to defend yourself against imminent physical injury. And the same applied with deadly force. If a person is attacking you with deadly force, it's imminent, not in the future, somebody thinking about doing it, right now, you have a right to respond in a reasonable manner. But the pre-existing law also had a provision that said you have a duty to retreat. If I come up to you on the street and I try to attack you with a weapon, and you can safely retreat, under the pre-existing law, you had an obligation to retreat. Zimmerman would have had an obligation to retreat. He had a gun. He had an obligation to retreat under pre-existing law. But that did evolve, and there are a lot of sociological reasons for it, a lot of reasons you can give, a lot of reasons that are argued for it. But eventually, it comes to mind, I have to say this, that we've always, as a culture, had a disinclination for retreat. I think, you know, we culturally just don't like the idea that if somebody's attacking you, I gotta run. One of the last cases I tried as a criminal defense attorney was a self-defense case where my client shot and killed an unarmed man. But that unarmed man had been threatening him and chasing him all around town and telling him what he was going to do to him and his mama and everybody else. He got tired of it. And this fellow came up to him at a convenience store, threw a beer bottle down the ground and came after him. He pulled out a .38 and put a bullet through his chest. And my argument to the jury was, how far did he have to run? How far do you expect him to run? How fast did he have to run? And that jury, 11 of them, voted to find him not guilty. One guy wanted to find him guilty of manslaughter. He shot and killed an unarmed man. So we've always culturally, I mean, it's always been a challenge from a prosecution standpoint to successfully prosecute somebody who has killed somebody who threatened them, even if it's an unarmed person. But you throw into that a lot of other cultural issues, and we can talk, I'm sure we will talk about these issues as we go on. But to get back to the original question, I'm sorry. Stand your ground laws began to evolve across the country. And there are a lot of political reasons for it. It got tied into the victims' rights issue. I think you all know that there has been a very strong victims' rights movement in this country, a very laudable victims' rights movement in this country. And somehow, and it shouldn't have happened this way, somehow the victims' rights issue got tied up with gun rights. And I think what you ended up getting from that was the stand your ground laws, which have had all the effects that we all are so concerned with. And stand your ground law basically says, what it did was it went back to that basic common law that was codified under Alabama law up until about 2006, I think it was. And it takes it beyond that. It gives you the right to use deadly force, not only when you're threatened with deadly force, not only when you're trying to prevent a rape or a kidnapping or a sodomy, but when your house is being broken into, or your car is being broken into. It really has put property rights above human rights in many ways. You have a right to defend your car, or your property, or your house, even if you're not threatened with imminent physical harm. You have a right to pull a gun and kill somebody. Now, that's what it is, basically, and it does two more major things on the stand your ground law. It gives you the right to use. There is a presumption under the law that your use of deadly force is justifiable. A presumption. It basically puts it on us who are trying to prosecute these cases, a burden of trying to disprove that it happened. And how do you do that when your victim is dead? You got one version of what happened. The dead man can't speak. And the other thing it does, in Alabama does have a version of stand your ground law. It's in there. You have a right to stand your ground. The other thing it does, and this is a huge problem, legally, it actually makes the person who uses that force immune from prosecution. You cannot be prosecuted. It's the only provision in the law in Alabama. Alabama has no procedural rule that allows you to have a case dismissed before trial. You can dismiss it at the close of the state's case. But to dismiss that case before it ever gets to a jury, you can do that under stand your ground law. And it was done in St. Clair County on a case where a man killed a fellow on his property. That case was thrown out by the judge, never saw a jury. And it was upheld on appeal. So those are two major issues and two major concerns about the law. It does forge new ground. And it's something that, did I cover it all?
And it moves it away from the home too.
Exactly.
The council doctrine is basically your house, your property. And stand your ground is basically your personal space, and kind of move it away from your property to wherever you are, anytime you're in imminent danger.
That's absolutely true.
I'm sorry, is it, or you?
Well, yeah.
Okay. Every time you pause and I speak, then you start to speak it.
I'm a lawyer. What do you think? A lawyer's talk.
I want to switch gears here for a minute and talk about the politics of stand your ground, because no matter what, any law that gets passed through the legislature, whether it be on the state level or the federal level or even on the city level, whether it's something as big as the Affordable Health Care Act, also known as Obamacare, or if it's something even as small as a city ordinance that says no wearing blue shirts on city streets past 10 o'clock p.m. no matter how big or how small a law is, every law that's passed has some type of political consequence. And when I say consequence, the word consequence doesn't necessarily always mean something bad. The word consequence simply means something that has happened as a result of something. That can be something good or that could be something bad. So every law that passes through legislature and it's signed into law, it has political consequences. So I want to turn this question over to David E. Reddick. Since you sit on the city council, I want to know what are some of the political consequences of standing your ground, and how has it affected the country politically, especially since the Trayvon Martin case and several other stand your ground cases that have become high profile since then?
Well, politically, the political consequences is this. You have certain levels of judges. You have judges that are elected, and you have judges that serve as that are appointed and they serve a life term. And when you have an elected judge, that judge has I guess they have more of a constituency pull more than just the duty of being a judge. So you have that judge that when they have to make a decision, they kind of start thinking, how is this going to affect me in my next election cycle? And so you have the ability to take something that may not be just. It could be on the plus and negative side. You can take a situation that may not be just and bring enough public awareness to it to that judge will say, well, if I don't deal with this, if I don't handle this a certain way, it may cost me my judgeship, it may cost me my job in the next election cycle. So you have that political aspect that actually kind of can sway the way that we deal with things, the way that a judge may look at it, whether he'll even accept it as standing ground or not. And so politically, that's kind of your big to-do about it. It's, will I get any kind of political fallout based off of this decision? And if so, how do I handle that? So, you know, you have times where, like in Trayvon's case, you know, the judge wasn't even going to see it. It wasn't, like the attorney said, it wasn't even going to make it to the light of day for a trial. But because of the political heat that was turned on to that judge, it actually saw a trial. You know, and that was actually groundbreaking because according to Stand Your Ground, if Stand Your Ground is accepted, it doesn't even make it to the courtroom. So that we have the ability through politics and involvement to actually force justice from the people. Like Dr. King used to say, the power of public opinion. And if we can make something, if you can make the public aware of something strong enough, you can sway the opinion of the judge, of the jury, of your politicians, of the lawmakers. You know, I use public opinion in what I do to just to get money put in education. You know, I have to make it a big PR campaign so that my counterparts would be afraid to vote against me raising money for education because they're afraid of the political fallout. So really, that's what it comes down to. When you have a judge that's an elected person, they have a duty as a judge, but they also have an obligation to their constituents. So I guess if you want justice and fairness, be a loud enough constituent to where that judge doesn't want to just ignore you and vote. You know, and the problem with elected judges is, you know, to run for office as a judge, you don't got to be good at what you do. You just got to be more popular than the next guy. So sometimes we get dummies on the judge stand. I don't.
Make sure you say that. I didn't say that.
I said because you get somebody on the judge stand that was more popular than the next guy, but can't tie their shoes, you know, if a mirror's in front of them. So we got to make sure that as a constituent, as a people that vote, these judges have, you know, God forbid you're ever in a situation where you have to stand your ground or you have to make a decision when it comes to either your life or the next person's life, you have to choose whether you want to live or you want to let that other person live, and then you have to go before a judge. You need to make sure when you cast your ballot that you vote for a judge that's going to understand that, you know, this person's life is in danger, and I understand, you know, their concept, not just a judge that's going to think, well, they're poor, so they don't matter. So it's up to us to make sure that we vote for the right kind of judges and make sure we hold them accountable.
Do you think that politically, are people more so in favor of stand your ground, or are they more so against it? What's the political climate around the whole stand your ground issue? Do you find politicians nowadays saying, okay, yeah, we can have this in our state, or do you find politicians saying, no, we might need to get rid of this law? Or does it depend on where you live? Because if you notice, if you look at a map of where a lot of stand your ground laws are, they're right here in the southern part of the United States. So is it really about where you live as far as the political climate, excuse me, the political attitude towards stand your ground?
I think yes. It's absolutely, it's the region you're in. If you're in Calhoun County, Alabama, you know, the majority of the people are gonna be more pro stand your ground.
Why do you think that's the case?
Because everybody's got a gun, you know, so you go to California, you know, most people are anti-gun, you shouldn't even have a gun in their opinion. So it becomes the mentality and the personality of that climate. It's that political climate that determines it. But at the same time, you got different levels of problems too, because then you got issues where, you know, you may be in a section, a region that has a lot of racial turmoil and racial injustice or racial, you know, inadequacies, where you actually have, if you're black and you try to pull the stand your ground defense, it's not going to happen. And if you're white, you pretty much, anytime you do it, it's a stand your ground law passes, you got those kind of climates to where when you're in that situation, you got people that are really against it. But I think it comes down to having a better understanding of what the stand your ground law is. And when we talk about reform, doing the reform in a way that it makes sense if there's a reform. But I think we are opposed to what we hear because we hear the rhetoric, but we don't really, how many people truly have an understanding of the stand your ground law? How many people have actually gone on the internet and looked up the law and read it for themselves to see exactly what it means?
Maybe that's a good time to find out. Raise your hand if you've actually gone online to study about stand your ground, if you've actually done research on it. Well, Councilman Reddick, you got your answer. Okay, now I'm going to switch over to the law enforcement side of all of this. As many of you know, in the case of Trayvon Martin, the reason why that Sanford Police, this was according to the former police chief Bill Lee. You know, Bill Lee, that was the guy that was ousted from the Sanford Police Department as a result of the Trayvon Martin case. Well, the reason why Bill Lee says that he did not feel that George Zimmerman was properly arrested, as the world felt that he was not. The reason why he was not properly arrested because they said that it was a violation of his Fourth Amendment rights. How many of you all know what the Fourth Amendment says? Raise your hands. Okay. Well, I'm going to tell you what the Fourth Amendment says. The Fourth Amendment, in the case of George Zimmerman, it says it requires any warrant to be judicially sanctioned and supported by probable cause. The issue in the George Zimmerman trial, in the George Zimmerman case, was that they could not prove, or they did not have enough probable cause to rebut George Zimmerman's claims of self-defense, which was why he was not arrested until 40-some-odd days later. The only reason why that was the case was because Angela Corey, as you all know, she's the prosecutor that became famous around the world from the Trayvon Martin case. It's because she came in and decided to file second-degree murder charges against George Zimmerman, and that's the only reason why he was arrested. He was not arrested by Sanford Police because they felt that it was a violation of his Fourth Amendment rights, because there was no evidence to prove that George Zimmerman was not defending himself. So I want to bring McGlaughn, who was with the Heflin Police Department. I want to ask him, when the police arrived to the scene of a crime, okay, here it is, it's a dead body, blood, and then you have a guy standing there. He's obviously the culprit. There are no other suspects around. How do police officers determine if that he was using self-defense or not? How do police officers determine probable cause?
Probable cause, when you arrive on scene, can be determined by other witnesses if there's any somebody else around. It doesn't have to be a visual witness. A neighbor could have heard something. And in the case of Trayvon Martin, there was people in the apartment complex that heard various things that they tried to piece together. You've got little things like gunshot residue on the incident with Trayvon Martin and George Zimmerman. If he was as close as he said he would, there would have been some type of gunpowder residue on his clothing, on his skin, something, instead of, if it had shot him at a distance, that wouldn't have been there. There's little clues and indicators you can put together there on scene. If I shot him at a distance and I'm not wanted to use self-defense, I'm not going to have blood splatter on me. If I'm closer, it's more probable that I am. There's a lot of little things. If it's inside a house, bullet trajectory, you can recover the bullets. There's a lot of little things like that you can pick up on.
So in other words, even with all the I guess, national outrage in that there was no arrest until 40 some odd days later, even then the police did not feel that there was enough probable cause to arrest George.
And it's something that he mentioned on a minute ago. He said there's a presumption of innocence. There is, but I'm going to say there's more presumption. You're innocent until proven guilty. If that was me in that situation, I can sit back and not say a thing. The prosecutors, the state, they have to prove that I don't have to prove I'm innocent, they have to prove I'm guilty. So if you don't have that Fourth Amendment you were talking about a minute ago, that probable cause or reasonable suspicion has to be supported by oath or affirmation. If I'm a police officer and it's not there, I can't make it happen. I'm not going to put my name on a report where I've insinuated something that's not true. You've got officer discretion on scene too. It doesn't necessarily mean he won't get arrested. It means we're going to look into it and see if we can find something later. You'll have evidence after the fact from autopsies, or sometimes after a situation like that. It takes a few days for people's nerves to calm down, or them to come forward. Witnesses are scared. They don't like to come forward a lot of times. So after a couple of days, you may get something else to come forward, and you'll get that reasonable suspicion or probable cause that you can start building your case on. If it's not there, you can't make it. You can't make it happen. You can't make it so. Just like he said a minute ago, dead men can't tell you their side of the story. You're innocent until proven guilty. If your story doesn't match up, then you can start building on that reasonable suspicion. But initially, with no other witnesses, if his story pans out as far as bullet placement, the gunpowder residue, all those little indicators, those little clues, that's what you have to start building off of. So
in other words, the issue with the Trayvon Martin case was that they know that there's a dead body here, and they know that they know the man. There's a George Zimmerman was 27, 28 years old at the time. They know there's this grown man that had shot and killed him. But in other words, the police could not say whether it was murder or manslaughter or any of that. They had no idea what it was.
Not having been there. I'm
not
saying
having,
yeah.
Right.
Like I said, that's not saying they totally thumbed their nose at it. That's just saying they didn't make the arrest then. You can always work a case later.
And so do you think, let's just say, had the governor the pressure not been put for another prosecutor to come in and investigate, and prosecute the case, do you think had the system just been allowed to let it run its course, do you feel that maybe later on down the line, Sanford police would have thoroughly investigated the case and would have successfully brought charges against George Zimmerman?
I don't know if there would have been. Essentially, the officers that were on scene initially, with a not guilty verdict, essentially their theories were backed up. His story matched, panned out, as was supported with the 911 phone records. I don't know if they would have. If this is all the evidence we've got, this is all we've got to work on, I don't know that the arrest would have been there. Now, I'm assuming Florida's got some sort of law. The Code of Alabama gives the district attorney the authority to give the sheriff initiative, or not initiative, to tell the sheriff to investigate certain things and prepare special reports. So the district attorney could have stepped in himself if Florida has that same law. And I'm not familiar with Florida law at all, but Alabama doesn't do it. Am I correct?
Yeah, there is one other wrinkle too. I'm not. As I mentioned a while ago, another problem with the stand your ground law is the officer. I mean, the shooter is effectively given immunity from prosecution. I mean, you actually cannot charge him or prosecute him if he basically makes out a case for self-defense. So I think that was one of the reasons why there was a delay also. And in some states, I'm not sure if Florida does or not, but in some jurisdictions, the officer is actually civilly liable. You can sue the officer, get a judgment against him if you arrest you unlawfully. So I mean, it's for understandable reasons, they were being very careful about bringing up charges.
And the thing about it is too, keep in mind, that it has to be a pretty clear-cut case for an officer to make the arrest based on what he finds out. Otherwise, if it's questionable, he's gonna take it before the district attorney and let them issue the warrants, and then he's not gonna be liable. He just serves.
In regards to police response to a crime scene, picture this scenario. Screaming woman, 911 call, police arrive at the scene. It's obviously some type of domestic dispute. I want to be able to discuss with everyone the domestic violence side of Stand Your Ground, because I speak especially for a lot of the women in here. Many women have concerns that if they are in an abusive relationship and their life is in danger and they stab or shoot their partner, that they could go to jail for trying to stand their ground. Let's try to hear this story for a minute. 33-year-old Melissa Alexander, she's a woman from Jacksonville, Florida. She was convicted in 2012 of 3 counts of aggravated assault with a deadly weapon for firing warning shots at her estranged husband and his 2 children in a domestic dispute. This is according to her. Now, although no one was injured in the shooting, she was sentenced to 20 years in prison for the incident. However, she has been granted a new trial, and it is expected to take place sometime in July. Now, obviously, I know that that's not a case here in Alabama, and it's not a case that you can comment on because that's something that's being dealt with in the state of Florida. But how does a police officer respond to a domestic dispute if a woman has called and said, my husband was trying to kill me, so I shot and I killed him first? How do police officers respond to that?
It's funny you brought that scenario up. That happened in Weaver probably, I'm gonna say 6 or 7 years ago, and I was one of the responding officers. Not the lead, I didn't take over the investigation, we brought investigators out. Domestic violence is a little different as far as stand your ground type stuff. In this kid's situation, you have a victim, the husband, who wasn't killed, he was alive, correct?
Yes.
Alabama domestic laws are that if you can determine the primary aggressor, something has to be done, because again, we can be held civilly liable. If I fail to take action, I leave and say, hey, y'all calm down, I don't want to have to come back out here again tonight. If I leave and that escalates further and the person gets harmed or killed, I can be held civilly liable. If I show up on that case, I'm going to have my victim. She shot at me. And I asked her, she says, yeah, I shot at him, he was chasing me or whatever. I don't know that he was chasing her, but it has been proven. She said, yes, I shot at him. To me, that's going to be my primary aggressor initially. I'm going to take the burden off of me, and I'm going to let the judge decide that later.
Any panel want to comment on that?
Well, under domestic violence in Alabama law, the officer is required to make an arrest if he sees evidence.
It actually says if you can't determine the primary aggressor, you need not, or if you can determine the primary aggressor, the officer need not arrest both parties, but if you do, you've got to take action.
I actually had a situation, a case I'm trying to help somebody with now, where the girl, her boyfriend, her child's father, was actually, she had a, what's it called? She had a restraining order on her. He forced his way into the house, started beating her up. She grabbed a gun and tried to shoot, but the gun jammed. And he took it from her, and he tried to shoot her with the gun, and it jammed also. And they actually arrested her for having the gun and attempting, but it's really, she should have been covered under stand your ground because he broke into her house. He had a warrant, she had he had been arrested for it before, but she was the one on trial for pulling the weapon, which actually was his gun. It just so happened to be in the house. And, now she's facing jail time because of it. And, she happened to be African-American. I'm wondering if she was white, would she still be facing, the same charges? Or would she be covered under stand your ground?
Chief Giddy wanted to respond.
Well, I just want to say that, make sure everybody understood too, that domestic violence, you can arrest one or both. In other words, if you see clearly these two people right here got into it, and she's saying he assaulted me, but he has a bunch of injuries and marks on him, well then, she's going to jail. And she's not, you know, she doesn't have any injuries. There's times when you arrest both, and the thing to keep in mind, the law goes further, and like it does on other laws. And once you arrest somebody for domestic violence, it's mandatory. They have to stay in jail 12 hours before they can even make one. And that is set up that way to give the other party the opportunity. It should be a cool down period for the one arrested, the aggressor, and then it gives the other party time to vacate, you know, or make other arrangements.
In order to, I guess, successfully get away from.
Separate themselves so that there will be no further escalation.
In the situation I was talking about, there was an active protection from abuse order in place. Now, she had gotten on him. Most PFAs are good for after you need to get them extended. Soon after she got it and it was served, they reconciled the differences, moved back in together, and they had not done away with that PFA. There was an active PFA against her, and I didn't say to him that he was chasing her with a ball bat. She did make contact with Will. He did not die, but she was found not guilty from it. There was a PFA in order, and he was chasing her. And it's a case-by-case scenario. You've got to determine whether you're justified in using that deadly force. Well, can you kill somebody with a baseball bat? Absolutely. So.
Well, what about an instance where I think everyone in the room probably knows someone that has been affected by child abuse, the defenselessness of a child, and that they're not really able to fight against someone as big as their parents. Okay, so let's just say you have a 12 or 13-year-old kid at home, and he or she is being abused physically by their parents. Does the child have the right to stand their ground and potentially kill one of their parents if it's a situation of domestic violence?
It's going to have to be a pretty severe case. It's legal in Alabama for parents to use corporal punishment on their children. It's legal to whip them within the boundaries. Now, if we get there and they've been whipped with a lamp or this computer, things are different. That's outside of normal parameters. I'm saying stand your ground self-defense applies to everybody, regardless of age, regardless of color, white, black, red, purple, yellow, I don't care, regardless of age too. If we show up, and it's something pretty significant, if that kid can articulate why he did what he did, I don't see a problem with that. Now, if he did it because he's mad and the parents took his Nintendo away from him, that's not justified. You know.
In regards to here at the university, you know, in a university environment, people would like to think, oh, this is a safe, wonderful place and nothing bad could ever happen. And what a lot of students would like to know is, let's just say if it's an instance where they're inside of their dorm room and one of their dorm mates is coming at them with a knife. The stand your ground law does say that inside your home, you have the right to protect yourself if there is an imminent danger. A dormitory would be a place where a lot of students would consider home. It is where they live, essentially, and where they lay their head at night. What about an instance, what about a stand your ground case if it was inside of a dormitory?
You can't have a gun on a college campus.
He said, nah.
Well, but like you pointed out,
It's
stand your ground
still
follows you. I mean, if I'm out here in
Yeah,
front
it
of
does.
It's still the same. You can be in violation, and the university can actually hold you responsible for a violation of their rules. You know, if you're not supposed to have that now, then you violated that policy, the school's policy by having it. So, but that's not going to be an arrest. Could you be removed from school for that? Yes. You got to go to college. But will you be arrested?
I think what you're referring to is the Gun-Free School Zone Act of '94, which is federal law, and I've read over it, but I've never really seen any punitive measures for that. Now, keep in mind at the same time, we can't enforce federal law. Kind of like the No Child Left Behind Act. One of the stipulations in that says, you know, no tobacco use on school property. But if a parent lights up at a football game, we can't necessarily arrest them. It's not illegal to have that cigarette. I haven't seen even where a federal officer would come in and arrest, like I said, it's against, you were saying our victim that was being attacked with a knife shouldn't have had the gun on school property either. I haven't seen any punitive measures even federally where that would have been an arrestable offense.
Okay, well, it would be different as far as, JSU, you can't have a, knife, you can't have that either. Like I said, most of those things will be dealt with on a university policy violation. Now, if you're in violation of the law, yes, you will be arrested. But as far as you defending yourself.
Yes, does the person have the right to defend themselves?
You can defend yourself. I mean, this was even before stand your ground. You can defend yourself against a threat anyway.
What if you're in a public vicinity? Let's take it a little further. If you're in a public vicinity such as the cafeteria, and someone that you've been having some problems with for a while decides they want to come approach you, grab you by the head and start beating your head on the floor, does that person have the right to stand their ground and execute whatever force necessary to remove that person from them, even in a public place at the university?
They have to do it lawfully. That's what you got to look at. In other words, the one that did the first attack is committing a crime. So that's unlawful. They can defend themselves against someone unlawfully attacking. And it really doesn't matter where it is.
There's nothing in the law that
Now,
says
what
somebody
you
got to be.
got to keep in mind is you got to look at how you do it. Are you justified in doing it?
The degree of the attack, everything's a case-by-case scenario.
Yeah.
Just like I said a minute ago with the ball bat, let's take that, let's change it from a ball, well, let's leave it a ball bat. You've got a weightlifter, he's 6'6", 350 pounds, great big arms, he comes at you with a ball bat, he's got the physical capability of killing you with that ball bat. Now, we've determined that ball bat could be a deadly weapon. 98-year-old grandmother comes at you with that same ball bat, you're gonna have a hard time explaining yourself why you did what you did. It's a case-by-case scenario.
And that's what I wanted to ask. It depends on where it is. I mean, do you feel like, as I understand it, I'm no expert. I haven't taken the bar. I had to say that before I said this.
Yeah.
But, as I understand it, is, if you feel like death or personal injury or,
reasonable apprehension of death or serious.
It depends on where this person coming after you. How are you in fear of your life? Do you feel like this guy's going to kill you? Or do you feel like this guy might beat you up? And at the end of you might get a beat down, but you don't think the guy going to kill you. You might flood in your nose. But, I mean, it depends on, where you going with it. I mean, if the guy's been messing with you around campus all the time, he might trip you or push you down the stairs or something like that. That's bullying. That's not attempted murder. So would the stand your ground even be a part of that discussion?
In your question, you put it specifically in the cafeteria, and I think you're trying to direct it, do you have the right to do it there? No. Don't lump it in the castle doctrine 100%. Right. It doesn't have to be in your house. You've got the right to defend yourself. Whether if you're merely existing, being you, you've got the right to go throughout your day without being assaulted. And if so, you can use a reasonable amount of force to get yourself out of that situation, whatever that may be.
And that's the big key, is the reasonable amount of force. If you're wanting to fight, you'll have the right to shoot you.
Or if you
basically, are 12 people qualified to find what you did reasonable.
you tell a judge asks you, why'd you shoot this man? He said, well, he pushed me. Does that authorize legal force? Not necessarily.
But you also have to interject what I said a few minutes ago about the cultural factor. Now, what all y'all said is absolutely correct on the law. But if you're in front of a jury and you're trying a case where you've got a guy who's, the case I gave, jurors are going to think, just everyday folks are going to think, well, I don't think you ought to have to run all over town chasing you. You're not going to chase me all over town. At some point, I'm going to protect myself. I'm not going to take a beat down, and the jury's probably not going to panic.
The best way I've heard the castle doctrine explained, somebody told me a dog won't even let another dog run around his own yard.
Yeah, that's right.
You can occupy your space and be you without having to be, without somebody else violating your rights.
It seems that there's a lot of, I guess, when you were talking about the jury, Assistant District Attorney Reid, it seems that there are a lot of conflicting areas in the criminal justice department from the moment police arrive on the site. You have the police and their handling of the situation, then you have the DA's office and their handling of the situation, and then you have the judge and his handling of the situation in the vicinity of his or her courtroom, and then you have the jury. So you have all these people deciding the fate of one person, and unfortunately none of them were there to see any of the actions take place, but yet all these different people are deciding what happens to that person. How does that make it difficult for people to really understand what stand your ground is when you have all these different facets of the criminal justice system making these decisions?
Well, jurors are people. Jurors are people who live in the community, they live their lives, they bring all their collective experiences, their lifetime experiences with them to that seat in that jury box. And that's one of the things that makes this issue so complex and so difficult for a lot of us to deal with. You have a culture right now where there are a lot of people in our communities, black and white, who feel basically besieged. They feel like, they don't feel really safe outside their homes, they don't feel necessarily safe walking the streets, and they bring all that with them to a jury box. And you get into a situation where there's some sort of cultural red flag, some sort of red flag go up, and they associate it with something in their experience. And some of y'all aren't gonna like this, but I'm gonna say it. I go to homicide scenes. I go to, I'm there when suspects are interrogated. I'm there when folks are laid out and covered up in body bags. And I've seen too many dead young black men with thug-like tattoos, with bullets. Some of y'all might have on your cell phone right now a screensaver that's bullets. Some of you might have these little pistol things on your key rings. I'm not saying y'all do, but I've seen a lot of them. I even saw my daughter with a screensaver that had bullets on it. I told her, take it off. But I mean, we have cultural issues going on where a certain lifestyle is glamorized in our communities. And there are some people who take it too far. And they end up either on a slab or in prison because of it. And, there are folks who are dealing with that every day in their everyday lives. Older people in our communities, all across this country are dealing with it. And when they come in that jury box and they see certain things, or red flags to them, they think, how would I feel if I had a gun and this person's coming up to me on the street? What are they going to do to me? And those are the people we have to deal with in the jury box. And that's why you end up with a case where you're trying to self-defense case and you got somebody who's killed somebody and somebody who maybe has done anything like that before in the past. And they've got an antagonist on the other side who's bringing his issues and maybe threatening them and that sort of thing. They bring all that. See, the judge makes a decision as to the law. The judge tells the jury what the law is. But that jury decides how to apply that law to those facts. And they're going to bring their experiences with it. And if they're living in a house in a neighborhood that's changed and people are breaking in their homes and they don't feel safe outside on their own streets, they can't divorce themselves from that. And that experience comes to it. And that standing ground factors into it. Because all these cases that we've given so much attention to in the past, where folks have taken it too far, the excuse is always going to be, I felt threatened because I saw him as the other. The other. Somebody other than me, somebody different than me, somebody threatening to me. And there will be some folks in that jury who might connect with that. So, I mean, this process is imperfect. Well, I bring my experiences, and all of us bring our experiences to it, and we do the best we can.
And that's something you always have. You always have that human element that's going to be in there. I actually like law and reading cases and stuff like that. I think the law is a beautiful thing, but you can't divorce that from the human element, because, like in the case of Trayvon and the woman, what was her name?
Marissa Alexander.
That's the same prosecutor. Same prosecutor.
And it's interesting what a lot of people said about the Marissa Alexander and the George Zimmerman case. It's the same prosecutor that prosecuted the case, Angela Corey. She went so hard to try to prosecute George Zimmerman, but the shoe kind of came on the other foot for Marissa Alexander. Why do you all think that was the case?
It's that human element. Like you said, you have your own prejudice inside of you, and And like Mr. Reid was saying, Attorney Reid was saying, you may have, somebody could have broken your house last week and now you sitting on the jury stand, and this kid who have no priors or anything else, he's the enemy to you. Or you could have been raised in that kind of environment to where, there's elements of society where, and it's not right, but, sometimes whites feel threatened by blacks. Sometimes blacks feel threatened by whites. And, sometimes we're physically intimidated by these people, and they're not psychologically intimidating people, but sometimes you have the human element, that prejudice, that internal prejudice that we don't divorce ourselves from when we make a decision on how to impact the rest of someone's life, how to impact how the rest of that person's life is going to be, how to impact their freedom, whether or not they get to see their kids or raise their kids again. There's a case in, I think it was in Florida, where a guy who was 6 years in the Air Force was outside the club. He got jumped. He had his pistol on him, and this group of people went to attack him, and he pulled out his pistol and didn't shoot anybody. He shot to get everybody away from him, but a bullet fragment hit someone's leg, and they gave him 20 years for discharging his weapon. He didn't get to use the stand your ground. He attempted. He didn't get to use stand your ground for that. And this Air Force military person with no priors or anything else, now he has a daughter and a wife at home that don't have a father, and they don't have that military income or anything else because the guy was protecting himself. He didn't shoot anybody. He shot at the ground, but the bullet fragment is on, and he's doing 20 years to life for trying to protect himself because the judge decided that wouldn't qualify for staying around. So you have that human element, that self-prejudice that we haven't learned how to divorce ourselves from when we're making decisions on something.
And two, you gotta look at the manner in which that force was used too. I can see maybe some situations, the State Chief Giddy here, he can, and he's intimidated. None of y'all have seen him stand up. Look at, he's like 7.5 foot tall. I'm 6'4" by comparison.
Just so you can see how tall I am.
So if he came at me and I took my pistol off my side and I fired rounds to give him a warning shot, I just shot. We've got rooms above us too. If I used my weapon in a negligent manner to cause my harm, and I'm not trying to play that. Well, I'm saying it could go through the roof and hit somebody. If I shoot it in the floor, it could go hit any one of you. So in certain situations, I don't see a lot of sentence for accidentally shooting somebody in the leg. But I can see where there could be some punitive measures for somebody negligently using a firearm. Now, I'm a gun advocate, and I come from a gun culture. But if you use one stupidly, you deserve some sort of punishment. I'm not saying I wasn't there in that situation, but I can see where, if he just sort of wildly popping off rounds anywhere close to a nightclub, I can kind of see that.
Chief Giddy, you wanted to respond?
I just wanted to say that what Marcus said a while ago is true, and it has things that we don't think about every day. How many kept up with all the House bills that have been voted on and everything going on? Well, this right here this started out that way. And you know who pushed this through, voted on it, and then signed it into law? It's your elected officials. And if you don't, and what they do is they react to what people are telling them. And if you read this law, it's obvious when this came into effect. It looks to me very obvious that it was right around the time a lot of carjackings and things like that because it specifically mentioned. And people are contacting those representatives and saying, this ain't right, this happened. This happened here in Anniston. I think everybody probably knows the case of carjacking. So they're reacting, they write a law, a bill, and then they push it forward. And if you don't keep up with that and somehow say something about it and make sure that these people know what you were wanting from them, then they may go based off of what a small group that's been affected by that.
It's like, we had a big, in the 2010 election, we had a big movement movement that happened, and the result of that was a lot of college tuition got reduced. You know, we don't have as much Pascal money as we used to, but that came out of, you know, us electing people, our votes. So if you're not paying attention to who you're putting in office, if you don't see voting, you know, it drives me crazy when I hear somebody tell me I don't vote, you know, or I don't get into politics. I mean, you know, if you're not educating yourself, if you don't know who you're voting for, or if you're not aware of who you're voting for, first of all, as a black person, you should never say I don't vote. As many of us had to die and get beat just for the right to vote. I was at a conference in D.C. and all the elected municipal officials. We went and met with minority Congress people, and one of the congressmen said, "You know how many times I've been to," yeah, I got to excuse the Navy language, but he said, "You know how many times I've been to jail just for the right to damn vote?" And then they're trying to change voting laws. It's up to us to stay vigilant, to stay aware, to put people in office and elect people that's going to have our, you know, our best interests at heart. If you want college money, you need to make sure that who you vote for is an advocate for education. If you want fair justice, you need to make sure that that judge that you allow to go in office is going to be a fair judge. You got to look at his track record of what he's doing and not doing. Once a person takes a judgeship, once a person is elected to judge, there's like 90% chance of staying in office if somebody runs against them. So once that person is in office, we become just almost catatonic, and we don't look into what their decisions were. We don't pay attention to what they're deciding or what they're doing to us. And it affects us. I mean, I like the opportunity to go to college and get an education. I hope you guys do too. But that opportunity is dependent on your ability to go out there and cast a ballot and know that your one vote is one vote, but that one vote is important. You know, Hitler made it into office off of one vote, and he changed the whole world. So you can't be negligent and catatonic. I mean, it's almost you dealing your own death blow if you're not paying attention yourself.
And you got to keep up with what's going on after you put them in office, because this right here would have started out either in the House or the Senate, and then it would have passed one, and then it would have went to the other, and then the governor hasn't signed it into law. So if you keep up with this stuff, you can call your senators and tell them, send them emails, tell them you don't want it. If you don't like this law, make sure you express that.
They're supposed to be representing your interests. That's why you elect them from your area, your district, whatever. You communicate with them. They are supposed to vote or side with the overwhelming majority of their district to say, hey, this is who I'm representing, this is what I'm doing. That was, people overwhelmingly decided, hey, we have the right to defend ourselves.
In both the cases of Trayvon Martin and the Jordan Davis case, Jordan Davis, that was the young man at the gas station that was shot between 8 to 10 times because he got into an altercation with a 47-year-old man named Michael Dunn. Michael Dunn shot inside the car. He's since been convicted of 3 counts of attempted murder, 1 count of firearms in an occupied vehicle. Unfortunately for the family of Jordan Davis, the murder charge he was mistried on, and according to prosecutor Angela Corey, that case will be retried. Excuse me, that count will be retried at a later date. 2 things that I noticed back when I was a reporter. I noticed that a lot of people were talking about what's called the mind your own business law. It was something that was repeated over and over and over and over again with both the Trayvon Martin and the Jordan Davis case. It said that sometimes there are people who feel the need to butt in and intrude on other people's lives, as they said that George Zimmerman intruded in the space of Trayvon Martin. They say Michael Dunn intruded in the space of Jordan Davis and his friends. They said that many people say that Michael Dunn could have just drove to another gas station, or he could have went to another spot. He did not have to stay there and listen to the music, and nor did he have to start any confrontation with the young men. How do you all feel about the whole mind your business law, and why do you think people say that? Why do you think that term is used?
Well, I hadn't heard it. But, you know, well, I was about to say, there is a, you know, in the self-defense law, there's in Alabama's law, and we talk about
100% for a blanket statement of mind your own business to the laws, but because we've got a duty to help our fellow man too. You know, if I see something going where, I want to pick on Alex Ference for a minute and Teddy Copeland because I know them. If I see Alex pull his gun and point it at Teddy's head, and it's unwarranted, but I don't know them in this scenario. I can't just let a murder take place. You know, I can see where I would step in and at least try to stop it. Or if there's a domestic violence situation, I can see where as trying to be a good person, you can step in and say, hey, you know, stop, and then take it from there. So, I mean,
Well, and the scenario, I'm sorry, the scenario that you gave between Mr. Copeland and Mr. Ference, that was a situation in which a violent encounter was taking place and someone's life was in danger. I'm speaking about the scenario in which that person is not doing anything to the other person. They're minding their own business and someone comes and says, hey, what are you doing? Or stop doing this or stop doing that. That's the scenario that I'm speaking of. I wanted you all to respond to that.
I don't know, I just don't have, to me, it's hard to see when somebody will come and create something. It's not there. In other words, if you're not engaging in any illegal activity, then I don't see whether it'd be a reason to, unless they were.
I heard, oh, by the way, I was going to let you all know, there is a question and answer session at the end of this that was in the flyer, and I'm going to grant that to you all in the next 5 minutes or so.
I think that's the case of, parents should have booked you.
Well,
I'm trying to tie to that case, you know, is what we're all trying to bring it back to. They're saying, I guess maybe George Zimmerman should have let somebody peacefully walk to this apartment complex and go through. Some of that basis was he was supposedly charged with this neighborhood watch program. There'd been some break-ins and he was investigating. I can see where, you know, if we've all banded together as a community and I don't know this certain person who's walking through our apartment complex, good people. I mean, if you say, hey man, what are you doing around here? Like, oh, well, my car broke down and I'm just trying to walk to the gas station. You know what, have a good night, man. I don't think it played out that way. I can see why he would at least try to investigate. Now, from the time that case happened, he called the police department. He was on the phone with the dispatcher walking through, following him, lost him, and then turned around and left. I can see where, you know, if somebody's in my yard, I don't have the duty to mind my own business. I'm going to check him out.
what about in
But
the
the
situation?
police had told them not to pursue.
Yes, you're right.
What about-
I spoke to a neighborhood watch group last night, where the whole point was for neighbors to look out for neighbors, you know. Obviously, you want people to be in the neighborhood, to be concerned about what's going on in the community. And I just finished prosecuting a murder case, where we probably would not have caught the defendant. He would probably not have been apprehended, but for the fact that some folks got involved. And they call in and tell what they saw, so we want people involved. But now, you know, obviously there's a line to be crossed at some point where you become an aggressor and you provoke provocation. And that obviously can lead to a situation that you don't want.
Well, what about in the situation in the that Florida movie theater where the two men got into the altercation because the man said that he was texting, the man said that he was distracted by the man's texting in front of him. The reports say that the man that was killed was texting his 3-year-old daughter's babysitter to make sure that his daughter was okay. In a confrontation like that, you're inside a movie theater, there are plenty of seats. A movie theater is probably as big, if not bigger, than this room that we're in right now. Why could that police officer, that retired police officer who was so disturbed and distracted by the text messaging, did he have the right to move somewhere else in a case, in a situation like that? Because most people probably say, well, he didn't have to start a confrontation with this man. He did not have to get out his gun and shoot him. I believe if you look at the surveillance video of what it was that the victim had thrown at the suspect, it looks like a box of popcorn. And so, why do you think that he felt the need to stand his ground inside of a large space where he had every opportunity to remove himself from the situation?
I say anybody can really justify that situation. I think maybe as Americans, we're kind of cocky by nature. We're egotistical. We don't want to be walked on. You know, our parents tell us when we're going through school, you better not start a fight, but you better finish it, that kind of thing. That situation was not, anybody ever heard that before? That situation was not warranted at all. That was his ego letting him get the better of him, and he wasn't be man enough to walk away from the
We
situation.
should have more work.
Your $5 movie ticket doesn't guarantee you the enjoyment of the movie. So I can't see anybody look at that situation and say, yeah, he was right.
Some final, I want to get some final remarks from you all, and I would like for each of you to respond appropriately. A lot of people feel that the stand your ground law is a life taker, and that even though stand your ground was intended to save a person's life, people are now under the impression that stand your ground is now something that is taking people's lives. It's taking lives more than it's saving. I want to respond to all four of you. How can people not only make themselves more aware of stand your ground, but how can more lives be saved and not unnecessarily taken as a result of stand your ground?
Education. Read the law. Can I write a citation on the board? So they have it.
Oh, yeah. I have no problem.
I will play the devil's advocate on this one just a little. I don't see it as a life taker. I see it as being able to defend yourself with the whole duty to retreat and stuff like that. If we started enacting stuff like that, I'm gonna use my wife as an example. She and I have two small children. We've got a 1-month-old and a 21-month-old. If she has a duty to retreat, she's just hindered herself. Does she leave it? Say she's in Walmart parking lot, buckling the kids in the car seat. Somebody comes up, does she leave the kids in the car? She has a duty to retreat. She's just being her. She's shopping and going throughout her day. Does she take the extra time to get the kids out of the car seat and then run? Now she's hindered the two kids running. I don't see it as a life taker. I see it as being able to exist, to be you and go throughout your day. With that,
It was meant to be a good thing, I
Right.
believe. You know, people try to fix problems, and I think they did it for it to be a good thing, where that you could defend yourself without having to worry about being prosecuted for doing it. I think it probably started out to be a good thing.
No, some good things do turn into.
Right. Well, it's like anything else. People manipulate things. And that, and at the same time, the person that's going to manipulate that still probably going to be the
if there's
type of
one,
person who is going to use that when it's not needed.
there's one thing you can get from it, know that every case isn't a lethal force situation. In law enforcement, we have what's called a use of force continuum. It's a list of steps you take leading up to deadly force. Deadly force is the last option you get. It starts out with officer presence. Generally, when we show up, people go, crap, the cops are here, and they all calm down. The next step up is force commands. Hey, stop doing that. If that doesn't work, soft emptying, and you move up. Just because somebody may get confrontational with you doesn't necessarily mean every case is a lethal force situation. In that case, with people misconstruing it as being a life taker, I can see where they're misunderstanding the law and what it was intended for.
I think it comes to knowing, being aware, know it, read it, know it. When I was the NAACP president, the majority of the problems I dealt with was, and most of the time people came to me after they had already pled or the case was over or whatever, and it was too late to do anything, but most people just didn't know their rights enough to get the proper representation. The more you know about your rights, what's available to you, what you have the right to and not to do, how far everything goes, you know, the more you know about your opportunities, the better protected you are. And, you know, sometimes we're so apathetic that we don't, I just thought about it, the word pathetic is an apathetic. But the more apathetic you are on what your rights are, I mean, you should know how to conduct yourself at a traffic stop and know what your rights are. You know, if a police officer asks you if you have a weapon in your car, it's not smart to say, no, you want to check, because of course they want to check. They wouldn't ask you if they didn't want to check. But if you don't offer them the right to check, then 9 times out of 10, they're not going to search your car. But it goes from that all the way up to stand your ground. Know what your rights are, what you have the right to do and not to do. Know where you're supposed to be protected from. And life is a lot better, you know.
Be careful when he says know what your rights are. You can read this. This law is not that long. I'm sure everybody is familiar with immigration. I mean, some of these things, if you read, you can be justified using one portion of this, but if you don't read the complete thing and read it thoroughly, right down here, you thought you were doing what you were justified doing. You turned around and violated it in another section. So, and the bad part is, I mean, most people probably, you know, unless you're a lawyer or something, in a lot of cases, you're not gonna be able to read this law and understand it.
You know, it's very complicated. As I said before, the previous self-defense law was fairly simple. If someone faces you with physical force, you have a right to respond in kind to defend yourself, basically. But this law has laid out a whole lot more circumstances where you actually can use deadly physical force. And it's not just to defend yourself, it's not just to defend yourself with deadly physical force, but it does have exceptions in it. If you read down there, if you're yeah, exactly. There's also about nuclear reactor or there are things there about being in a
reactors, but you have to work there to do it.
well, yeah, or you could be maybe in a drug house. If you're in a house where drugs are being sold, it may not apply. I mean, if you're in an illegal activity and that sort of thing. But my final thoughts on this is this, and I'm conflicted on it. And I can tell you for sure, as a prosecutor, this law is not our friend. It's much more difficult to prosecute homicide cases and cases of serious physical injury because we have to deal with that whole immunity issue before we even. And I've had only one case where I actually had to litigate the stand your ground law. I had a African American young woman whose boyfriend broke into her house. Well, basically, they had an altercation in one location. He followed her home after she was taken home by her friends. He broke into her house and was coming toward her. Now, he was being restrained. So she was not actually being threatened. Because there were other people in the house that were holding. But she grabbed a butcher knife and stabbed him in the chest and killed him. We had to have a hearing on immunity. Under those circumstances, I mean, put yourselves on the jury. You've got a young woman who's going home, whose boyfriend has chased her home, forced her way in the house, they're trying to come after her. And she got a knife in her hand. Maybe she meant to stab him, maybe she meant to scare him. Are you going to convict that guy? Most of you, if you're on the jury? You would.
No.
I want you on my jury. You know, because the guy was unarmed. But most people are going to sympathize with the woman who's outweighed by 60 or 70 pounds, by the guy who breaks into the house. And you know, so it's a matter of, that was a difficulty I had. You know, he ended up being convicted of manslaughter in this case. But as a prosecutor, it's a difficulty. The law is confusing. You got a judge that interjects himself in the place of the jury, who can throw a case out without even getting to it. So I mean, it's very confusing, difficult to understand. And by the time the judge in the Trayvon Martin case had charged the jury, it sounded almost as if she was, I think it was a man, he was telling them to find him not guilty. If you just listen to the language of the law, I mean, it is confusing. And from a law enforcement standpoint, it creates issues for police officers about whether or not they should even arrest a person. So from that standpoint, it creates a great deal of difficulties. But I'm 60 years old, and I can remember a time when, in the 1960s, when if I had been approached by a certain group of young white men, and I was in a place by myself, I might have felt like I need to pull out a gun and shoot somebody. So I mean, you have to kind of look at it from a standpoint of perspective and experience and culture. And we do have a culture where we do believe in defending ourselves. And is it something that's been abused? Has there been miscarriages of justice? Yes, I believe there has been. The case in Florida, and Florida's law is much more, is a little more extreme than ours is. But yes, I do believe that people got away with something they should have been convicted of in Florida, in the Trayvon Martin case specifically. And in the other young man specifically, I personally believe they should have been convicted. But is it a complicated issue? It certainly is. And I think we have to keep all that in mind when we think about it.
If you would too, try to take away from this, there's no window of lapsed opportunity, window of lapsed time where you can use this. If this man assaults me, beats me down right here, and I go back to my house and get a gun and shoot him, I can't articulate why I felt threatened because I removed myself from that situation initially. I deal with this a lot with juveniles with fights, and parents get involved all the time. They say, "Oh, my son was just defending himself." Not 3 periods later in the school day when him and 3 of his friends came back, they're letting their egos get in the way. If he beats me down and then I see him walking down the street and I shoot him out my kitchen window, I'm not gonna be able to say I was defending myself. I wasn't standing my ground at that point.
Can I give our panel a round of applause? A lot of information to take in. I know it wasn't even just for me, just listening as the host. I'm going to open up the floor now for people to ask some questions. I know some of you have them. Hopefully they have been answered within the duration of the conversation with the panel. But in case they have not, I wanted to open that floor up. So,
Can we exempt this for Alex Barnes? He's smiling at me.
who had what? Yes, sir.
Even with the Fourth Amendment includes deadly force within unreasonable search and seizure, you know, if a person's unarmed. Do you feel that this law tips the balance of power toward the citizens having more opportunities to use deadly force, whereas law enforcement has to be very careful with that Fourth Amendment?
I personally don't. I think we all kind of have the same power and authority. You just got to use it wisely. I'm going to very respectfully disagree with something you said earlier as far as being able to protect property. I don't see being able to use deadly force. If you're breaking in my car, I'm a cop. I know it's a felony. I've watched it take place. And I said, hey, stop, and you turn and run. You just committed a felony in my presence, but you're posing no threat to me. I have no right to shoot you. Now, if I'm sitting in my car and you're busting my window out, I can articulate why I may feel threatened then. But I don't see where it tips the balance. Everybody's got to use some common sense in this and act responsibly.
This does overstep that because it's pretty much just plain and white when he says, you know, you just can't be arrested because you actually, I guess you'd say because you shot someone or, you know, with your Fourth Amendment. In this law, it's almost like you can't be held responsible then and there. In other words, you got to prove that, you know, the evidence may kind of suggest that. But then, you know, it just says that you can't be held responsible for, you know, shooting someone who's breaking into your car.
Well,
You need to be able to, it shouldn't take away where you got to justify it, I guess.
well, I'm going to respectfully disagree as well, because,
We all respectfully disagree with you.
well, I'm going to say this. You know, I understood the law to be just what you said. Until I started kind of looking it over a little bit before this session today. And there actually is a provision, which is shocking, in the standard ground law that says, and I hate to read it like this, but I don't know any other way to do it. In the process of unlawfully and forcefully entering, or has unlawfully and forcefully entered a dwelling, residence, business property, or occupied vehicle, it authorizes the use of deadly force. It is. And there's even a case, now I just kind of looked at material, though I saw a case in Florida where a man chased a person who had broken into his house and stole some radios. He chased this fellow down, stabbed him to death. And his defense was the guy threw the radios after him after he chased him 2 blocks. The guy threw the radios at him, so he gets him down, stabs him about 5 times and kills him. And the judge actually, I think I wrote down the language, it was so bizarre to me. The judge said the defendant was well within his rights to pursue the victim and demand the return of his property. That's purely a property issue there, but you know, but we don't see that, and that always was the law up until this one.
Now, I can see that being occupied. If the house is occupied, I mean, the car's occupied. But to get back to your question, keep in mind though, that as law enforcement officers, we don't get a free pass. If I'm involved in an officer-initiated shooting, it still goes to the grand jury, and they either indict me on it or no bill. They look at all the stuff too, just like an average citizen.
That's correct.
Does anyone else have a question? Okay, yes, you.
It seems like throughout history, self-defense has always been determined by, if it's not clear that it was self-defense, it's been determined by the jury. And so my question is, do you, one, think this law takes away that from the jury? And two, do you believe that it is a jury question of self-defense.
I say absolutely yes. That, your judge ruled on that case I had. We worked with Judge, we're gonna work with Judge Overstreet in our circuit. And we had that case I told you about, the woman that stabbed the young man, that was in Judge Overstreet's court. And our primary argument, as far as I know, it hadn't been litigated, but that one time in St. Clair County, our primary argument was that with the judge making that decision invades the province of the jury. The jury should make the call on the facts. The judge shouldn't be the one who's acting maybe for political reasons, or who were maybe acting for personal reasons. Or we may have just some personal, inclination one way or the other. The jury of 12 collective citizens with their collective wisdom should make that call. So I absolutely say yes, to make the province.
This does short circuit.
Well, make you guys afraid to make an arrest. I mean, you may be sued under some of these jurisdictions if you arrest a guy and he claims that he committed.
And like we said, if it's not a clear-cut case, the officer will not go away to the arrest. Like you're talking about Trayvon Martin, if it's not a clear-cut to them, but they're not gonna make it. They're gonna take all the evidence and the statements from everybody involved, let the DA read over it, and the DA will return on the report.
We had another situation here in Calhoun County where a store was being robbed. For the most part, the store clerk was letting it happen until one of the suspects turned one of the guns at another person in the store, in which case he returned fire. He was able to articulate, now, the store clerk was also in a wheelchair. He was able to articulate why he did what he did, and he wasn't, he was defending the life of another.
In a case like that, the person, if the store clerk shoots the robber and another robber's in the store with him, that other robber is responsible for the death of his friend, the person that he was robbing the store with. So the store clerk actually wouldn't even be prosecuted, it would be the person that committed the robbery with him.
Any more questions? Yes.
Okay. Just one, please, if you don't mind. Okay, God forbid something happens. You dial 911, law enforcement shows up, and probably to you, counsel, what's your advice? What do we do?
You mean if somebody's in your house?
No, well, no, I mean, if we have to use,
Show up?
if an incident happens, okay, God forbid, and we call law enforcement, we dial 911, the officers show up, what's your advice?
Have you shot somebody?
Well, I mean, there's a person laying there, there's me, right? I have my gun on the ground, right, and I'm standing there, right? What happens next?
My advice is,
Get a lawyer.
listen to the police and get a lawyer.
No, well, that's my point. My point is, you make your rights, you have the right to remain silent,
Well,
and you exercise that right.
My advice to anybody that I worked with when I was with the NAACP is, don't antagonize the officer when they get there. Listen to them, be, courteous as possible, but don't say anything until you talk to your attorney.
Well,
And I'll let the attorneys.
well, I might answer this differently when I do private practice. But seriously, I think, if you acted responsibly, if you got somebody breaking in your house and you feel threatened, your family feels threatened, and you feel like you have to defend yourself. I mean, that's why this law was passed. That's why legislators felt like it was a legitimate act of their legislative authority to get past this law. I mean, you have a right to defend your family. I mean, I'd rather be standing over him. What was I saying about I'd rather be judged by a jury of 12 or carried by 6? I mean, if you really feel threatened, you have a right to defend yourself. And if that's the circumstance, I mean, this is what I'd be arguing about the prosecutor. If you put somebody down and you're standing over them with a smoking gun and you don't want, you wait until you get into a courtroom to say why you did it. Even though you have a Fifth Amendment right, and the prosecutor can't comment on the fact that you invoked your Fifth Amendment right, that jury's going to be wondering why you waited until you get in the courtroom to claim self-defense. I mean, you may not be charged at all if they know all the facts.
Now give them a private practice answer.
Yeah.
It depends on what he did.
I think the first thing, my advice is when the police get there, put the gun down.
On the initial response,
That's good advice. You may be on the ground next.
an initial response by law enforcement, I know you be directed towards him, I'm just trying to interject a little bit. I will say be cooperative. If you're within your rights, you know, you can tell them, you've got the right to remain silent. Now, I'm an officer, I show up on scene, there's a man laying dead on the floor, and I've got the resident of the house sitting there not saying a thing because that's his right not to talk to me. I can articulate why I may think that a murder happened. And just like we explained a minute ago, that has to be supported by oath or affirmation. I'll put my name on that one. I showed up, there was a dead man, this guy was not cooperative, something happened, you know. You may get let off in court, you know, but the initial response, I'm gonna say be cooperative. You got that right to defend yourself. You know, just.
Well, I've heard it where, you know, emotions are running high. The officer is there, we know you have the right to remain silent. He said, you know, can you tell me what happened?
And don't wait for that Miranda right, because that doesn't necessarily have to happen every time. To be read your Miranda.
All it means
At that point, you think,
what
well,
what you say can be used
Right.
against you.
Exactly, that's my point.
Now, at this point, keep in mind, we walk up and you start saying stuff, just because I haven't read your Miranda rights yet, doesn't mean we can't use that also. But the only time you would have to be read your Miranda rights is if you're in my custody and I'm questioning for it. Don't get the TD mindset where every arrest comes with that Miranda right. It doesn't happen that way. I don't think. Right.
And the officer has the right to investigate, you know, to talk to witnesses, talk to people on the scene. At that point, you're not necessarily a suspect.
If you're within your rights, you're gonna be okay. I would say be cooperative. Number one, like I said, put the gun down. You did right by doing that. But, other than that, just be cooperative. Cops aren't bad people. We're not out to get you.
That's not the point, but sometimes, like I say, when emotions are running real high, and I know they will, a lot of times, sometimes you might say something that you be misconstrued.
Keep in mind,
maybe it's not a bad idea to.
Well, I guarantee you, if you don't say anything at all, you're standing over with a gun, you're going to jail.
I can articulate that, but I'll put my name on that. Now, you got the right, you know you've got the right, you can call your lawyer. He may respond on scene, he may help you right then, that's always an option.
That's what I was doing.
There's some things you've got to talk about, and you've got to say, in other words. You're standing over somebody with a gun, they're not going to the officers, not going to let you walk off.
My gun? I got my hands like this, you know.
With arrest in Alabama, with a misdemeanor with the exceptions of DUI and domestic violence that can happen in my presence, I have to witness it happen. If I show up on DUI, the car's been wrecked, I can articulate he was driving, I can make that arrest. I show up on domestic violence, the lady said he's been beaten on me, she's got marks, it didn't happen in my presence, but I can make that arrest. A felony, I only have to have reasonable suspicion that it took place. I've got that reasonable suspicion, I've got a dead man on that case. I understand where you're coming from, but I'm like him, you're probably going to jail on that one. Just be cooperative. If you're in the right, you're in the right. That's not saying you might not go to jail, but you'll have your day in court. You'll get to be eventually, if you're right.
My advice is get at least 2 attorneys in case one don't answer. Car,
Well, yeah.
on speed dial.
I mean, and like you say, this gets convoluted and confused.
And get that car when you see him, and ask around, say who's the best at this, just from time to time.
Even though you said you put the gun down, I'm still gonna be able to put 2 and 2 together, and I'm gonna explain to the judge, I showed up on scene, he was the only one there was a gun, there was a dead man, he wouldn't say anything. We're covered too by what's called good faith. If I act in good faith within the scope of my duties, I'm gonna be okay. Civilly liable, wise, I guess.
Well, yeah, that's the other point. That's the other point. Thanks, appreciate it.
I'm going to allow one more question, and anyone else who does have a question, you can have a chance to interact with the panel once we dismiss. So I'm going to go ahead. Yes, sir.
Question. Okay, say you've had, say 45 years of martial arts training, and you've taken courses that certify that you know how to kill people with a knife. If someone breaks in your home and you still defend yourself to kill someone with a knife, is it looked at it the same way? Or is it taken differently because of your training?
To me, I mean, what we look at is what you did justified.
I don't think so. I could be a ninja in my spare time, but if I take the chance to disarm somebody, I still risk getting hurt or serious physical injury. I come at you to take the gun away from me because I know this high-speed, low-drag move to get the gun away from me, but it still goes off. I don't have to take that risk just because I have this training. One case, I saw a situation one time where an officer was up against a very much bigger subject, and he was being very uncompliant. And this was a fairly former Marine, he had a lot of training, he was a weightlifter, and the suspect told him, well, he was holding the taser, and he said, why don't you put that taser down and fight me like a man? And the officer told him, because I don't have to. You know what I mean? I don't necessarily have to take that risk of me getting hurt. If you've got all that training, I still think you can do whatever you need to do without taking unnecessary risk.
So if I break down, they're not gonna take, it's gonna be looked at as just someone.
I think if you're justified,
You're gonna look at whether your action is justified.
Yeah, if you're justified, you're justified.
Based on all the facts and circumstances, I mean, you consider all the circumstances, and what you could reasonably perceive, what you saw.
And the lawyer's ability to articulate that.
Well, he's got a lot of faith.
Please give our panel another round. I also would like to take this time to recognize our university president, Dr. Bill Meehan, and if he has any remarks that he would like to give, I will give you the opportunity to do that now.
Well, I just appreciate everybody coming, and thank you for being here. Ed, appreciate you holding this forum very much. I thank our panelists. Let's thank them again.
I just saw another candidate running for office walk in, Jackson Montgomery, who's running for county commissioner.
How you doing, Mr. Montgomery?
Local celebrity, Landon Brooks, everybody's photographer. Good to see you today.
At this time, I would like to ask all the members of the JCRI, please come forward. Y'all look good. Y'all can take a picture of this. If you have camera phones, picture phones out, just start tagging if you want to. This is a really nice picture. I would really like for somebody to get it. I just first of all would like to say to each and every one of you, thank you so much for your dedication and your service to this organization. It has meant the world to me that you all have decided to take time out of your schedules to be a part of this. I did this, at one point this was just a dream, it was. And then I started putting it down on paper and it became a reality. And I thank you so much from the bottom of my heart that the hand of God was in this each and every single day. And I wish you all very well in your future endeavors and whatever it is that you decide to pursue. So it is my prayer that you have found this organization over this past semester to be pleasurable and that it has been well with your heart as it has been with mine. So I just wanted to take the opportunity to bring you all to the front and publicly recognize you. Thank you. Did anyone need to take a picture of the group before they sit down? Okay, thank you. If there are no other remarks from any other elected officials or anyone else running for office in the room, I don't want to miss you. Okay. I thank you all so much for taking the time to come out here.
No, it's not.
Oh, you're speaking to Landon, okay. Thank you all so much for coming out here. If you all would like to interact with the panel, for if you needed a question to ask them, they're right here for you. God bless and good night.
Also, get some food on the way out.
Y'all need to take a picture of the panel before y'all.